Welcome to the Hood Rat to Harvard podcast. I am your host, Chandrika Simmons, also known as the Law Chick. Well, the TikTok ban is in full effect. And guess what? TikTok has filed a lawsuit challenging the law. Let's read it on this latest episode of my podcast, Hood Rat to Harvard. Hello. I am live streaming on YouTube as well as Instagram. So welcome. It's my first time on Instagram. So hello to everyone. So be patient with me as I navigate this. But this lawsuit, which was filed on yesterday, is 70 pages long. But we got to read it because we need to know what the fuck is going on. Don't we? We do. All right. Hey, Pumpkin. One of my kids is in my live. Hey, Poo Poo. I love you. All right. So, in the United States Court of Appeals for the District of Columbia Circuit, TikTok Incorporated and ByteDance Ltd., that's ByteDance Ltd., the petitioners have sued Merrick B. Garland in his official capacity as Attorney General of the United States. So as you may not know, or as you may know, and what you should know is that he is the Attorney General. That means he is the lawyer for the United States. He is our lawyer. We pay his salary. Okay. And anytime you sue in a federal court entity, you have to sue the person who's over that entity. And then in this case, that's Merrick Garland. All right. Appointed by your current president. All right. So the lawsuit is 70 pages. I haven't looked at it at all, just download it. So it might have a bunch of counts on it. I don't see a table of contents, which would be nice. Let me just see who their lawyers are real fast. Let's go look at that, see who the lawyers are on the case. So it looks like the lawyer for TikTok is Alexander A. Berengal. So Alexander, Alexander, middle initial A, last name Berengaut. So that looks like top. All right, so let's see. All right. So interesting. The corporate disclosure statement says that ByteDance Limited is a privately held corporation incorporated in the Cayman Islands. Not China, not Japan, the Cayman Islands. Let's see. And subsidiaries provide a suite of more than a dozen products and services that allow people to connect with, create, and consume content on the internet. And it's a TikTok is a California incorporated company that provides the TikTok platform in the United States. TikTok Incorporated is a wholly owned subsidiary of TikTok LLC, which is a wholly owned subsidiary of TikTok Ltd. TikTok Ltd is a wholly owned subsidiary of ByteDance Ltd. TikTok Incorporated has no other parent company and no publicly held corporation owns 10% or more of its stock. That is important because, why is that important? That is important because the whole farce by your Congress people was that this is a foreign company, and therefore they're going to steal all our data and information and sell it and yada, yada, yada. Bunch of bullshit. straight trash. Lies in the pits of hell. Lies. Hey, K Lex. All right, so let's get to reading. Let's see if there's anything else in here let's see what their requested relief is. Let's see what they're asking for. Before we begin and what they pled, let's see what they're asking for. So petitioners respectfully request that this court grant the following relief. A, issue a declaratory judgment that the act violates the U.S. Constitution. B, issue an order enjoining the Attorney General from enforcing the act. C, enter judgment in favor of petitioners. And D, grant any further relief that may be appropriate. All right, so let's go up here and let's start with this petition. So the petition reads, Petition for review of constitutionality of the Protecting Americans from Foreign Adversary. Adversary. I think it's adversary. I don't think they spelled that right. Foreign Adversary Controlled Applications Act. I'm going to read that again. Petition for review of constitutionality of the Protecting Americans from Foreign Adversary Controlled Applications Act. Okay. Congress has taken the unprecedented step of expressly singling out banning TikTok, a vibrant online forum for protected speech and expression used by 170 million Americans to create, share, and view videos over the internet. For the first time in history, Congress has enacted a law that subjects a single named speech platform to a permanent nationwide ban and bars every American from participating in a unique online community with more than 1 billion people worldwide. Whoa. All right. Thank you, Norman. All right. Ooh, that's a lot. Number 2, that law, the Protecting Americans from Foreign Adversary Control Applications Act, also known as the Act, is unconstitutional. Banning TikTok is so obviously unconstitutional, in fact, that even the Act sponsors recognize that reality and therefore have tried mightily to depict the law not as a ban at all, but merely a regulation of TikTok's ownership. According to its sponsors, the act responds to TikTok's ultimate ownership by ByteDance Limited, a company with Chinese subsidiaries whose employees support various ByteDance businesses, including TikTok. They claim that the act is not a ban because it offers ByteDance a choice: divest TikTok's U.S. business or be shut down. It's an end note. A footnote, and it says references to TikTok Incorporated are to the specific U.S. corporate entity that is a petitioner in this lawsuit and publishes the TikTok platform in the United States. All right. But in reality, there is no choice. The qualified divestiture demanded by the act to allow TikTok to continue operating in the United States is simply not possible. Not commercially, not technologically, not legally, and certainly not in the 270-day timeline required by the act. Petitioners have repeatedly explained this to the U.S. government, and sponsors of the act were aware that divestment is not possible. There is no question the act will force a shutdown of TikTok by January 19, 2025, silencing the 170 million Americans who use the platform to communicate in ways that cannot be replicated elsewhere. Of course, if a qualified divestiture were feasible, the act would still be an extraordinary and unconstitutional assertion of power. If upheld, it would allow the government to decide that a company may no longer own and publish the innovative and unique speech platform it created. If Congress can do this, it can circumvent the First Amendment by invoking national security and ordering the publisher of any individual newspaper or website to sell to avoid being shut down. And for TikTok, any such divestiture would disconnect Americans from the rest of the global community on a platform devoted to shared content, an outcome fundamentally at odds with the Constitution's commitment to both free speech and individual liberty. Ooh, that was a mouthful. Let's see. There are good reasons why Congress has never before enacted a law like this. Consistent with the First Amendment's guarantee of freedom of expression, the United States has long championed a free and open internet, and the Supreme Court has repeatedly recognized that speech conveyed over the internet fully qualifies for the First Amendment's protections. They're citing cases. I'm not going to read those. And consistent with the fundamental principles of fairness and equal treatment rooted in the Bill of Attainder Clause and the Fifth Amendment, Congress has never before crafted a two-tiered speech regime with one set of rules for one named platform and another set of rules for everyone else. In dramatic contrast with past enactments that sought to regulate constitutionally protected activity, Congress enacted these extreme measures without a single legislative finding. The act does not articulate any threat posed by TikTok, nor explain why TikTok should be excluded from evaluation under the standards of Congress concurrently imposed on every other platform. Even the statements by individual members of Congress in a congressional committee report merely indicate concern about the hypothetical possibility that TikTok could be misused in the future without citing specific evidence, even though the platform has operated prominently in the United States since it was first launched in 2017. Those speculative concerns fall short of what is required when First Amendment rights are at stake. Nor is there any indication that Congress considered any number of less restrictive alternatives, such as those that petitioner developed with the executive branch after government agencies began evaluating the security of U.S. user data and the risk of foreign government influence over the platform's content as far back as 2019. While such concerns were never substantiated, petitioners nevertheless worked with the government for 4 years on a voluntary basis to develop a framework to address the government's concerns. As part of this engagement, petitioners have voluntarily invested more than $2 billion to build a system of technological and governance protections, sometimes referred to as Project Texas, to help safeguard U.S. user data and the integrity of the U.S. TikTok platform against foreign government influence. Petitioners have also made extraordinary additional commitments in a 90-page draft national security agreement developed through negotiations with the Committee on Foreign Investment in the United States, including agreeing to a shutdown option that would give the government the authority to suspend TikTok in the United States if petitioners violate certain obligations under the agreement. What the entire fuck? This is crazy. Congress agreement aside, in favor of the politically expedient and punitive approach of targeting for disfavor one publisher and speaker, TikTok Incorporated, one speech forum, TikTok, and that forum's ultimate owner, ByteDance Limited. Through the Act's two-tiered structure, Congress consciously eschewed responsible industry-wide regulation and betrayed its punitive and discriminatory purpose. Congress provided every other company, however serious a threat to national security it might pose, paths to avoiding a ban, excluding only TikTok Incorporated and ByteDance Limited. Indeed, for any other company's application to be banned, Congress mandated notice and a public report describing the specific national security concern accompanied by supporting classified evidence. For petitioners only, however, there is no statement of reason and no supporting evidence with any discussion of the justifications for a ban occurring only behind closed doors. Congress must abide by the dictates of the Constitution, even when it claims to be protecting against national security risks. Against those dangers as against others, the principle of the right to free speech is always the same. Congress failed to do so here, and the act should be enjoined. So basically, they're saying this is an infringement upon free speech, and therefore the act is unconstitutional, and therefore it should be set aside and deemed to be unlawful. Woo! All right, so let me take a little break. Let's digest all of that. That was just the opening statement. Bitch, that was just the opening statement, baby. Whoo, baby. Whoo, that was a lot. Okay, that was the opening statement. They're asking for a lot. I get it. All right. They said a mouthful. So jurisdiction is proper. They did the jurisdictional statement. Now they're doing a background regarding TikTok is a speech platform used by 170 million Americans, yada, yada, yada. All right. We got it. They're telling us where they are. ByteDance launched in May 2017, yada, 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 over 150 countries, including the United States. Yeah. It has become the world's most popular application with over 1 billion users worldwide. As of January 2024, more than 170 million Americans use TikTok on a monthly basis. Users primarily view content on TikTok through its For You page, which presents a collection of videos curated by TikTok's proprietary recommendation engine. The recommendation engine customizes each user's content feed based on how the user interacts with the content that the user watches. TikTok's popularity is based in large part on the effectiveness of the recommendation engine. The source code for TikTok's recommendation engine was originally developed by ByteDance engineers based in China, and the engine is customized for operations in TikTok's various global markets, including in the United States. TikTok is not offered in mainland China. Oh my. They say previously the government made unlawful attempts to ban TikTok. Let's see. Okay, petitions were early stages. Okay, so under the Trump administration, they tried to ban TikTok. They're going through that. Okay, looking into the foundational First Amendment principles, and they're doing outlining that. Okay, so we're 14 pages in, and let's see, still doing background regarding it, and then they're talking about divestiture, meaning they want TikTok to give all their money to somebody else. That's insane. That the government can tell you to give all your money to somebody else, that you can't keep it. Bitch, what are you talking about? Whoo, what the hell? If we let this happen, that means you can accumulate. Here's the thing. It's like, which would be a good thing, if the government said, Walmart family, you're too big. We need you to give your money away. You think those Waltons wouldn't go kicking and screaming? Yes, the fuck they would. This is the same thing. This is basically what the government's saying. The government is saying, hey, Walmart, we see that you've grown big. We don't like that you're as big as you are. We don't like your impact on killing middle America. So therefore, we're asking that all the billions that you have accumulated, that you give those to another company, not yourselves, that you can no longer benefit from the company that you created. That is what this is. Walmart wouldn't let it happen, so why should TikTok allow the same thing? And if you're saying, oh no, this is a foreign company, it's not. It's not a foreign company. It's a company based right here in America. And for those of you who oh no, it started in a foreign country. Your Walmart people have businesses and subsidiaries in other countries, just like TikTok has businesses and subsidiaries in this country. So I want you to keep all that in mind when you're going through this and dissecting it. Okay. All right. So the divestiture, they're saying it's impossible. We can't do it. We can't give our company away. Yada, yada, yada. All right. We got it. And the other thing is, we're China's bitch. We owe so much debt to China. Are you serious? And here's the thing. You have to look at it, the ban, look at it like this too. So the farce that the Congress fed us, that they're taking the American people's information and data, yada, yada, yada. Straight bullshit. Why? Because if you were so concerned with that, then you would not allow major corporations such as AT&T, T-Mobile, Hertz, all the car rental companies to outsource their call centers to countries that have access to all of our information. Hotels as well. So when you're calling, you can get someone from a foreign country, and they're taking all your information. They're taking your credit card, taking your credit card information, taking they know where your address is. They know all the things on your credit card, your address, all the things you would need to scam, the code, the expiration date, and the person where it's located, the address where it's located. All that stuff they allow. So I want you to keep that in context. All of that stuff they allow. They allow these major corporations to outsource that information to foreign call centers. They have no problem with that. Even some child support agencies outsource the call center portion of collection of child support to foreign countries. How do I know? Google me, bitch. I stopped the Wayne County Court from being privatized because that's what they wanted. They wanted to profit off of child support. You're not supposed to profit off of child support. They want to get rid of all of us who work there and give it to a private company who was then going to outsource the call center to a foreign country. So when you see your elected officials, actually lying to us in our face, telling us that they want us to that they're protecting our interests, it's a bunch of bullshit. Because if you were protecting our interests, you would not allow American companies to outsource their call centers and let foreign countries have access to all of our fucking information. It is absolutely insane. So there's that. All right, so let's look at the act bans TikTok and other ByteDance applications. So let's see. On April 24th, 2024, the president signed the Protecting Americans from Foreign Adversary Controlled Applications Act. The act prohibits on pain of draconian penalties, online mobile application stores and internet hosting services from servicing foreign adversary control applications within the United States. This includes the distribution, maintenance, or updating of a covered application through an online marketplace. Section 2G3 creates two classes of foreign adversary control applications covered by the Act. The first class singles out only one corporate group, ByteDance Limited, TikTok, their subsidiaries or successors that are controlled by a foreign adversary or an entity owned or controlled by the aforementioned, which is ByteDance. Okay. And they have a footnote that says TikTok is a platform, not a legal entity. Petitioners assume that Congress intended this provision to be a reference to TikTok Incorporated and further reserve their rights to amend this petition to include additional TikTok entities to the extent the government takes the position that other entities are covered by this reference. In any event, TikTok Incorporated is covered as an entity owned or controlled by ByteDance Limited. The Act deems any application operated by these entities a foreign adversary controlled application without any finding about why any particular application, much less every application operated by these entities, should be so designated. The second class creates a discretionary process by which the president can designate other companies whose applications will also effectively be banned. Under these provisions, the president may designate an application as a foreign adversary controlled application if several qualifications are met. Covered company, the website or application is operated directly or indirectly by a covered company, i.e. a company that operates a website or application that permits users to share content and has at least 1 million monthly active users. Controlled by a foreign adversary, the covered company operating the website or application must also be controlled by a foreign adversary, meaning it is headquartered in, has its principal place of business in, or is organized under the laws of a foreign adversary country, which currently includes China, North Korea, Russia, and Iran. A company may also be controlled by a foreign adversary if persons domiciled in any of the specified countries, i.e. China, Iran, Russia, or North Korea, directly or indirectly own at least 20% of the company. Not exempt under Section 2G2B, but Congress specifically exempted from the term covered company any entity that operates a website or application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. An entity that operates a single website or application of this nature thus cannot be a covered company, even if it is controlled by a foreign adversary, poses a significant national security risk, and separately operates an application whose primary purpose is anything other than allowing users to post reviews. presidential determination notice and report and judicial review. Finally, the president must determine that such a company presents a significant threat to the national security of the United States. Before making such a determination, the president must issue public notice proposing the determination and then provide a public report to Congress describing the specific national security concern involved, supplemented by a classified annex, and also explain what assets would need to be divested to execute a qualified divestiture. These presidential determinations are then subject to judicial review. Okay, so we got that. All right. So basically, this law is designed specifically for TikTok, but in their drafting, they realized that some other companies would be impacted, so they did a carve-out exception for them. So if those companies allow for you to post a review, such as Google, because Google takes all of your motherfucking information as well off of your goddamn phone, bitch. Anytime you're putting something inside that search engine and you click, I accept the cookies. If you don't go read what motherfucking accept the cookies means, that means Google gets to have all your information that you're inputting. So Google allows you to leave reviews. So now they're saying that any company that does everything that TikTok does, but allows you to leave a review, then they're exempt. What, bitch? What? That's just a second stance. So even if TikTok were to allow us to leave reviews, they still lose under the first stance. It's just crazy. Okay. Because that first stance is designed specifically for TikTok. It's just crazy. All right, so that's on page 26. We're going through other stuff, yada, 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 legal, blah, blah, blah. Congress disregarded alternatives to banning TikTok, such as the national security measures petitioners negotiated with the executive branch. So all that stuff they negotiated with them, remember that whole Texas thing they had negotiated? They came up with alternatives. Congress just rejected it wholeheartedly. But we already know why they rejected it, because there's an agenda here. You people on this app, on this damn dance app, TikTok, you exercise collective thinking when it comes to certain things. Y'all get on the same page with certain topics, and one of those topics was motherfucking overseas in the Middle East, and how y'all collectively work together. Them motherfuckers was so mad at y'all. McDonald's was mad, Starbucks was mad, and everybody else that y'all try to boycott was mad as fuck. And they said, we cannot let this happen. We got to punish these motherfuckers. And yeah, now y'all being punished. Okay. Okay, are we all clear? Everybody clear about what's happening and what's taking place? Okay. You're being punished, bitch, because there's power in the multitude. You have power in more than one. So keep that in mind going forward. If you want to shut all this down, you can. Don't go to work. Simple as that. Just don't go to work. Collectively, you shut all this shit down. You'll cripple the government in a week. In a week, you'll cripple them. It's just what it is. All right. So let's see. The draft agreement, they talk about the alternative that they wouldn't accept, grounds on which relief is sought. Okay, so they're not saying the grounds. They're saying there's a violation of the First Amendment. Let's talk about that. So the First Amendment was violated. They say the First Amendment to the United States Constitution provides that Congress shall make no law abridging the freedom of speech. U.S. Constitution. Okay. By banning all online platforms and software applications offered by TikTok and all ByteDance subsidiaries, Congress has made a law curtailing massive amounts of protected speech. Unlike broadcast television and radio stations, which require government licenses to operate because they use the public airways, the government cannot, consistent with the First Amendment, dictate the ownership of newspapers, websites, online platforms, and other privately created speech forums. Indeed, it's like the government saying you can no longer go on Reddit and say what you want to say, that they're going to shut down Reddit. If they did that, these introverted emos would be in an uproar. Because my kids be over there too, just yapping, saying what the fuck they want to. So that's what they're saying. Indeed, in the past, Congress has recognized the importance of protecting First Amendment rights, even when regulating in the interest of national security. For example, Congress repeatedly amended IEEPA, which grants the president broad authority to address national emergencies that pose unusual and extraordinary threats to the country, to expand protections for constitutionally protected materials. That's 50 USC section 1701-02. Accordingly, under IEEPA, the president does not have the authority to even indirectly regulate personal communication or the importation or exportation of any information or informational materials. That's at section 1702B13. Limitations that are necessary to prevent the statute from running afoul of the First Amendment. They cited a case. Yet Congress has attempted to sidestep these statutory protections aimed at protecting Americans' constitutional rights, preferring instead to simply enact a new statute that tries to avoid the constitutional limits on the government's existing statutory authority. Those statutory protections were evidently seen as an impediment to Congress's goal of banning TikTok, so the act dispenses with that. You know what I'm just now thinking? As somebody who's a litigator and has sued entities, and I had the law on my side and had my cases dismissed early on as an early attorney. What I realized was that sometimes they will dismiss your case. You might have the law on your side, but you don't have proper standing to bring the action. And that means that you are not the person that can actually sue on this issue. It's like you are a heterosexual person and you're suing for being discriminated against because you're gay, but you're not gay, you're heterosexual. So you're not the proper person. You don't have the proper standing to be able to sue because the law is discriminating against a gay person because you are not a gay person. You don't have the proper standing. I think in this case, we might get a decision or they might get something that says that they don't have the proper standing to bring this lawsuit to protect freedom of speech, because it would have to come from an actual person bringing the lawsuit, an American person who has had their TikTok taken from them. That might be a scenario that could possibly happen. So be on the lookout for that in the future. That could possibly happen. So keep that in mind. All right. The act's alternative to a ban, a so-called qualified divestiture, is illusionary to the point of being no alternative at all. As explained above, divesting TikTok Incorporated's U.S. business and completely severing it from the globally integrated platform of which it is a part is not commercially, technologically, or legally feasible. The act will therefore have the effect of shutting down TikTok in the United States, a popular forum for free speech and expression used by over 170 million Americans each month. And the act will do so based not on any proof of a compelling interest, but on speculative and analytically flawed concerns about data security and content manipulation, concerns that, even if grounded in fact, could be addressed through far less restrictive and more narrowly tailored means. Less restrictive and narrowly tailored are colloquial terms in the law. That means that if you pass a law and it's like overly broad, if you bring a claim that says this law is unconstitutional and it could have been done this way, means less restrictions on it and more narrowly tailored to meet the goal that you're trying to achieve, then the law would be deemed unlawful in its face. And the courts could say you got to go back and revise the law, or the courts could say we're throwing the whole thing out. Those are options. Okay. Let's see. Petitioners' protected speech rights. Okay, let's talk about it. They said they got protected speech rights. Let me see. There is a case, because I'm a former union lawyer. There is a case. I can't think of it right now because I'm drawing a brain freeze for it because I'm concentrating on this. But there is a case. I can't think of it right now, but it's a case against unions that the United States decided that a company had as much rights as a person, and therefore allowed it to have free speech through dollars, that it could give unfettered amounts of money to campaigns, therefore basically crushing unions because we don't have money like that, because union people are working folks. So they don't have money like big corporation does. So they basically said that big corporations are just like a person and they have the right to free speech too. So they could be laying their hat on that. So let's see. The act burdens TikTok's First Amendment rights in addition to the free speech rights of millions of people throughout the United States in two ways. First, petitioner TikTok Incorporated has a First Amendment interest in its editorial and publishing activities on TikTok. They cite a lesbian bisexual case there from 1995. TikTok is more than a passive receptacle or conduit for news, comment, and advertising of others. TikTok Incorporated's choice of material to recommend or forbid constitute the exercise of editorial control and judgment that is protected by the First Amendment. Okay, that's Miami Herald case from 1974. And the Knudsen case from 2023. They have a case from November 30th, 2023, recognizing TikTok's Incorporated's First Amendment editorial rights. Okay, that's good. As the government itself has acknowledged, when social media platforms decide which third-party content to present and how to present it, they engage in expressive activity protected by the First Amendment because they are created expressive compilations of speech. Okay, and they're citing this New Choice case from 2023. Okay, second, TikTok Incorporated is among the speakers whose expression the act prohibits. TikTok Incorporated uses the TikTok platform to create and share its own content about issues and current events, including, for example, its support for small businesses, Earth Day, and literacy and education. When TikTok Incorporated does so, it is engaging in core speech protected by the First Amendment. They cited the Sorrell case from 2011, the Net Choice case from 2022 and 2023. The act precludes TikTok Incorporated from expressing itself over that platform. Even if the United States TikTok platform could be divested, which it cannot for the reasons explained above, TikTok Incorporated's protected speech rights would still be burdened because the act appears to conclusively determine that any application operated by TikTok, a term that Congress presumably meant to include TikTok Inc., is a foreign adversary controlled application. The president appears to lack the power to determine that a TikTok Incorporated owned application is no longer being controlled by a foreign adversary and has no operational relationship with formally affiliated entities that are controlled by a foreign adversary. The act, therefore, appears to conclusively eliminate TikTok Incorporated ability to speak through its editorial and publishing activities and through its own account on the TikTok platform. Okay, so they might not have an issue with standing. Okay. For similar reasons, the act burdens the First Amendment rights of other ByteDance subsidiaries to reach their U.S. user audiences, since those companies are likewise prohibited from speaking and engaging in editorial activities on other ByteDance applications. The act is subject to strict scrutiny. That's a colloquial term in the law too, strict scrutiny. That means you have to look at it. If a law's been challenged, you have to look at it with the greatest amount of detail and bombastic side eye. Okay. The act's restrictions on petitioners' First Amendment rights are subject to strict scrutiny for three independent reasons. First, the act presents a content and viewpoint-based restriction on protected speech. The act discriminates on a content basis because it exempts platforms whose primary purpose is to host specific types of content, product reviews, business reviews, or travel information and reviews. The act thus distinguishes favored speech, i.e. speech concerning travel information and business reviews, from disfavored speech, i.e. all other types of speech, including particularly valuable speech like religious and political content. That's the Turner Broadcast case from 1994. They cited that. The act also discriminates on a viewpoint basis because it appears to have been enacted at least in part because of concerns over the viewpoints expressed in videos posted by TikTok users of the platform. For example, the House committee report asserted without supporting evidence that TikTok cannot be used by foreign adversaries to push misinformation, disinformation, and propaganda on the American public. But they do that every day via the news. Okay. A concern that in any event could be raised about any platform or user-generated content right. Similarly, Representative Raja Krishnamurthy, who co-sponsored the act, expressed the unsubstantiated concern that the platform continued to show dramatic differences in content relative to other social media platforms. Second, the act discriminates between types of speakers. As explained above, TikTok Incorporated is a protected First Amendment speaker with respect to the TikTok platform. The act facially discriminates between TikTok Incorporated and other speakers depending on the primary purpose of the platform they operate. Any application offered by petitioners is automatically deemed a foreign adversary control application without any exclusions or exceptions. By contrast, any other company's application can be deemed a foreign adversary control application only if the company does not operate a website or application whose primary purpose is to allow users to post product reviews, business reviews, or travel information reviews. They keep saying that because they're talking about motherfucking Google, bitch. They talking about motherfucking Google, bitch. I'm telling you. They like, if you letting Google do their thing of stealing everybody's information, then bitch, we want to do the same. The fuck? That's basically what they're saying. The act thus favors speakers that do offer such websites or applications over speakers that do not. Moreover, the act singles out TikTok Incorporated and other subsidiaries of ByteDance for unique disfavor in other ways, whereas other companies with ownership in the country deemed a foreign adversary, Walmart, become subject to the action's restrictions only upon a presidential determination that the company poses a significant threat. So that means that that there could be a company that looks just like TikTok, but if the president says, I don't think they're a threat, then they don't get banned. You hear that? Do you hear that? Okay. Okay. That's a lot of power for one man to have. People know my reference to Malcolm X. Okay. Whereas other companies with ownership in company, all right. So okay. ByteDance Limited and its subsidiaries are automatically subject to the Act's draconian restrictions by fiat. The standard and process that the Act specifies for every other company likely falls short of what is required by the First Amendment and other applicable constitutional protections. But TikTok Incorporated and ByteDance have been singled out for a dramatically different, even more clearly unconstitutional regime. With no public notice, no process for a presidential determination that there is a significant national security threat, no justification of that determination by a public report and submission of classified evidence to Congress, and no judicial review for statutory and constitutional sufficiency based on the reasons set forth in the presidential determination. The Act also draws a speaker-based distinction insofar as it specifically names ByteDance Limited and TikTok, and also exempts applications with fewer than 1 million monthly users, except if those applications are operated by ByteDance Limited or TikTok. Okay. Third, the act is subject to strict scrutiny as an unlawful prior restraint. The Supreme Court has consistently recognized in a long line of cases that government actions that deny use of a forum in advance of actual expression or forbid the use of public places for plaintiffs to say that they what they wanted to say are prior restraints. Prior restraints on speech and publication are the most serious and the least tolerable infringements on First Amendment rights. The Act suppresses speech in advance of its actual expression by prohibiting all U.S. TikTok users, including petitioner TikTok Incorporated, from communicating on the platform. Let's see, they cited the Backpage.com case from 2015. For those of you from New York know who Backpage is. Let's see, or they cited the Keith case from 1971. They cited the WeChat users case versus Trump from 2020. Let's see, the same is true of other ByteDance subsidiaries and their platforms, yada, yada, yada. All right, so they say the act fails strict scrutiny because it does not further a compelling interest. Strict scrutiny requires the government to prove that the restriction furthers a compelling interest, and is narrowly tailored to achieve that interest. If a less restrictive alternative would serve the government's purpose, the legislature must use that alternative. That's Playboy case. What was that case? What was Playboy's case? I forgot. The act fails on both counts. The act does not further a compelling interest. To be sure, national security is a compelling interest, but the government must show that the act furthers that interest. To do so, the government must do more than simply posit the existence of the disease sought to be cured. Rather, it must demonstrate that the recited harms are real, not merely conjectural, and that the regulation will, in fact, alleviate those harms in a direct and material way. Congress itself has offered nothing to suggest that the TikTok platform poses the types of risks to data security or the spread of foreign propaganda that can conceivably justify the act. The act is devoid of any legislative findings, much less a demonstration of specific harms that TikTok supposedly poses in either respect, even though the platform was first launched in 2017. The statements of congressional committees and individual members of Congress during the haste. Oh, it's dark. Bitch, it's dark. Oh my God. Okay. It's time for me to get out of here before my husband start calling. Members of Congress during the hasty closed door legislative process preceding the act's enactment confirmed that there is at most speculation, not evidence, as the First Amendment requires. Instead of setting out evidence that TikTok is actually compromising America's data security by sharing it with the Chinese government or spreading pro-China propaganda, the House committee report for an earlier version of the act relies repeatedly on speculation that TikTok could do those things. They cite the House committee report at page 6 that says TikTok could potentially be allowing the CCP to track the locations of federal employees and contractors. Google Earth tracks federal employees and contractors. The fuck? Uber tracks federal employees and contractors. Lyft tracks federal employees and contractors. They're not concerned about being tracked. That is not the concern. Whew, this is so tiring. Oh my God. All right, let's see. Speculative risk of harm is simply not enough when First Amendment values are at stake. These risks are even more speculative given the other ways that the Chinese government could advance these asserted interests using a variety of intelligence tools and commercial methods. The conjectural nature of these concerns are further underscored by President Biden's decision to continue to maintain a TikTok account for his presidential campaign, even after signing the act into law. Oh, the hypocrisy of it all, bitch. The hypocrisy of it all. So your president got his own presidential campaign TikTok account, and he ain't took that motherfucker down. Yeah, he concerned. He is not. Is it not hypocrisy, bitch? Is it not? Oh my God, on today. These motherfuckers, they just be playing in our face. Congressional supporters of the act have also maintained campaign accounts on TikTok. This continued use of TikTok by President Biden and members of Congress undermines the claim that the platform poses an actual threat to Americans. Hello. Further, even if the government could show that TikTok or another ByteDance owned application pushes misinformation, disinformation, and propaganda on the American public, House Committee report at page 2, the government would still lack a compelling interest in preventing Americans from hearing disfavored speech generated by TikTok users and shared on the platform just because the government considers it to be foreign propaganda. They cited the Postmaster General case from 1965. The act also offers no support for the idea that other applications operated by subsidiaries of ByteDance Limited pose national security threats. Indeed, the legislative record contains no meaningful discussion on any ByteDance-owned application other than TikTok, let alone evidence proving that those other applications pose such risk. The Act also provides neither support nor explanation for subjecting petitioners to statutory disqualification by legislative fiat, while providing every other platform and users of other platforms with a process that includes a statutory standard for disqualification notice and a reasoned decision supported by evidence and judicial review based on those specified reasons. Only petitioners are subjected to a regime that has no notice, no reasoned decision supported by evidence, and opening the door to, among other things, post hoc arguments that may not have been the basis for government action. The Supreme Court recently explained that the requirement of a reasoned explanation is meant to ensure that the government offers genuine justifications for important decisions, reasons that can be scrutinized by courts and the interested public. Accepting contrived reasons would defeat the purpose of the enterprise. And they cite the Department of Commerce versus New York case from 2019. Depriving petitioners of these protections imposes a dramatically heavier burden on the free speech rights of petitioners and TikTok users that is wholly unjustified and certainly not supported by compelling interests. The Act also fails strict scrutiny, because it is not narrowly tailored. Even where questions of allegedly urgent national security are concerned, the government must show that the evil that would result from the restricted speech is both great and certain and cannot be mitigated by less intrusive measures. And that's a CBS case from 1994. To satisfy narrow tailoring, the Act must represent the least restrictive means to further the government's asserted data security and propaganda interests. That's a Civil Communications case from 1989. And be neither over nor under inclusive. That's the Writers Project case, Arkansas Writers Project case from 1987. The Act fails in each of these respects. The Act opts for a wholesale prohibition on petitioners offering online applications in lieu of multitude of less restrictive measures it could have taken instead. As discussed above, petitioners have been involved in negotiations with CFIUS since 2019 over a package of measures that would resolve the government's concern about data security and purported propaganda related to TikTok. The terms of that negotiated package are far less restrictive than an outright ban. The negotiations have resulted in a draft national security agreement with which TikTok Incorporated is already in the process of voluntarily implementing to the extent it can do so without government action. That initiative includes a multi-billion-dollar effort to create a new TikTok U.S. subsidiary devoted to protecting U.S. user data and have U.S.-based Oracle Corporation store protected U.S. TikTok user data in the United States, run the TikTok recommendation system for U.S. users, and inspect TikTok source code for security vulnerabilities. They don't even require that for these countries that go over that outsource their call centers and outsource certain aspects of their businesses. They don't even require them to have secure information. If you go over there and look at those foreign call centers, you will see our information is spread all over, and they're selling it to the highest bidder. And that's why you're getting your debit card jacked, your credit cards jacked, your Venmo jacked, all that shit, because they're selling your motherfucking information with no parameters in place to protect it. And TikTok is offering to do just that. And they said, no, fuck you, because it's not about that. It's about something totally different. All right, so let's see. If executed by the government, the National Security Agreement would also give CFIUS a shutdown option to suspend TikTok in the United States in response to a specified act of noncompliance. Here's the thing. If they were to even win this lawsuit that the law is unconstitutional, unlawful, they're going to go back and redraft it and adopt that. So that's what happens. TikTok is going to get watered down, which is already in the process of getting watered down right now. If you clicked on it lately, you'll notice that you had to agree to the new terms and conditions. Well, everybody don't read them. Bitch, I read them. I sat and read them. It took me an hour to read all of them. And I screen recorded while I read it. All that shit is bullshit. What they're trying to protect is Jewish people, LGBTQIA people, and still infringe upon your freedom of speech. You can still talk about, you still use the N-word, you still call target Black people, you can still talk about slavery, you can't talk about the Holocaust, you can't talk about wars going over in Rwanda, the Sudan, the Congo. If you start talking about that, you're going to get flagged and your page can get taken down. You also cannot talk about telling your followers to come follow your other platforms. They're going to shut your live down. All that shit is in the new community guidelines that they rolled out, and the rules and regulations they just rolled out. I read that shit. This shit is wild. That shit is absolutely motherfucking wild. They actually cite in there that you cannot talk about the Holocaust, not even in an academic setting, unless you are deemed to be a part of academia. You still talk about slavery, even if you're not in an academic setting. The shit is wild. I kid you not. Read the shit for yourself. Go back and read it. It's just so much. Oh my gosh. Okay, I see you. They sell your phone number. Yeah, the fuck they do. Yeah, the fuck they do. They sell your shit. They ain't safeguarding that. Okay, so now we got that. Okay, we got that. Were they arguing? Blah, 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 blah. Okay, so we got these arguments now. What else we got? Okay, they're saying it still failed to scrutiny test. We got it. You said it. You said it. It failed the scrutiny test. What else we got? Let's see. At a minimum, the act fails intermediate scrutiny as well. Okay, so it fails on that level too. We all know, as lawyers, we know the act fails on so many levels, but it don't matter. They passed it anyway. The act forecloses an entire medium of expressions. Yes, it does. The act is constitutionally overbroad. Yes, it is. Ground 2, unconstitutional bill of attainder. Woo! All right. So a bill of attainder is like a legislative punishment of any form of severity of specifically designated persons or groups. The protection against bills of attainder is an implementation of the separation of powers, a general safeguard against legislative exercise of the judicial function, or more simply, trial by legislator. Okay, by singling out petitioners for legislative punishment, the act is an unconstitutional bill of attainder, which it is, because you single out a single entity, and you didn't do the proper documentation needed to get there. It's on strict speculation. That's crazy. It's akin to even though OJ was guilty, it's akin to OJ getting off in California, and then the Congress coming to summons OJ to come before Congress, and then they have their own trial on him and make a determination that he's guilty. Hold up, that ain't even your motherfucking job. That wasn't y'all goddamn job. Y'all can't do that. That's basically a bill of attainder. So I hope I explain that to you so you can get it that way. That's basically what a bill of attainder is. Bitch, that ain't your job. That's not what they hired you for. That ain't what we hired you for, bitch, to come in here and do that. To do that to individual citizens. That's not what your motherfucking job. You're supposed to regulate yourselves and each other and the government as a whole, not individual citizens, bitch. I don't know what you fucking doing, but that's not what you're supposed to be doing. So that's what they're saying, that the Congress can't do what they did because it's basically it's an unconstitutional bill of attainder. All right, so we got that unconstitutional bill of attainder. Let's see. What else y'all arguing? Let's see. Ground 3, violation of equal protection clause. So I argue this all the time in cases. I'm drafting 3 right now, 3 cases regarding the equal protection, and I always argue due process. That means you didn't give me proper notice. You didn't give me proper information regarding how I'm supposed to go do this to be able to protect my rights. And here, Congress is the same shit. They didn't give them proper notice. You didn't give them the opportunity to do anything, and to give them a deadline of a year, basically, not even a year, less than a year, to sell all their shit and do something different to avoid a ban. That's a violation of due process clause. So that's basically what they're arguing now on the equal protection. Okay, so let's see what else they're arguing. Let's see, equal protection, and then ground 4, unconstitutional taking. So basically it is. So unconstitutional taking. Let's see. The takings clause. So the Fifth Amendment addresses the takings clause. So let's see what they got to say about the takings clause. Let's see. The takings clause provides that private property shall not be taken for public use without just compensation. The U.S. Constitution Amendment, that's the Fifth Amendment, Act does just that by shutting down ByteDance U.S. business, or to the extent any qualified divestiture alternative is even feasible, it is not, compelling ByteDance to sell those businesses under fire sale circumstances that guarantee an adequate compensation. So let's just give you a personal example of a taking. So my office that I own, I bought it from the first black lawyer in Oakland County, Michigan. I bought it from his grandkids. It is placed on this street called Bagley. Well, if I go down Bagley and across the street, there's a Clinton River Valley Trail, which is it's a stream that runs underneath this whole city. This attorney's office used to be on Bagley, across the street, down the street. Well, the county decided that they wanted that land. He had built his practice. He had built his law office. The community built it for him. He had built that, and he had placed it right there. And it was over an area where they wanted to build the Clinton River Valley Trail, where people could bike and trail and walk the trail and all that bullshit. So what they did was take his motherfucking office from him. Said, we're taking this by the government. We're the government, and we say that we need this for a certain purpose, and we have the right to take this from you. And they did. But they don't have the right to take it from him and not properly compensate him for it. So what they did was come down the street, across the street, and build him this building to compensate him for the building that they took from him across the street. That's a taking. Okay? Hope we all understood what that was. Okay. All right. So TikTok is saying basically what you're doing is a taking. You're taking my stuff from me and you're not properly compensating me for it. If you're going to take it from me, you got to give me what it's worth. That's what they're saying. Okay. So we got that part. They arguing the takings clause from the Fifth Amendment. Okay. God. What else? Now we've done. We are requesting relief. We made it through. Praise God, from whom all blessings flow. All right. So we're going back to what they're requesting. So what they're requesting is issue a declaratory judgment that the act violates the U.S. Constitution, issue an order enjoining the Attorney General from enforcing the act, and C, enter judgment in favor of petitioners and grant any further relief that may be appropriate. Woo, we made it, bitch. Woo. We made it through. And you know who stuck with me the whole time? That motherfucking Kalex and Jamel. I appreciate y'all more than you know. Thank you to the Hood Rat crew. They're my diehards, baby. We be having lives. And anybody got a problem with my diction and how I pronounce words and how I associate words? I have a motherfucking degree in English, bitch. And I teach my children you say it right before you can say it wrong. And I can say it wrong, bitch, because I know how to say it right. So disrespectfully, fuck you hoes who got a problem with it. That's why it's Hood Rat to Harvard. Bitch. Hallelujah. She said, hey girl, I've been here. Let me see. Naturally Loves Shauna. Hey, Naturally Loves Shauna. Thank you so much for hanging with me. I appreciate it. You part of the Hood Rat crew. Thank you to the Hood Rat crew for being here the whole time. I appreciate it. Much love. All right. So that is pretty much it about the TikTok ban lawsuit that is going through. Come on, Ariella. And I hope I said your name right. And that's on Mary and that motherfucking lamb, bitch. And it is. And it motherfucking is, bitch. Bitch, I'm about, and it's your girl, Alexi. It's your girl, Alexi. I'm about to code switch like a motherfucker tomorrow. I got my OCBA Foundation signature event, bitch. I'm about to put on this cute little and I'm about to be prim and proper. And y'all know how I got that business card. Bitch, I code switch on my business card. You hoes could never. You hoes could absolutely never. So this is my business card, my newest one. Y'all see that? Ain't it cute? They too cute. Ain't they cute? Can you see them? Let's see. Yeah. Now you see them. You see my business card? Now let's code switch on these bitches. On the back, one says, do they got you fucked up? That's for a certain demographic. And the other says, hey, I'm all these things: a lawyer, mediator, general, guardian ad litem, labor employment guru. I'm everything. Bitch, you ain't never code switch unlike anybody else's. Bitch, you don't know me. You don't know me, ho. You thought you knew. You have no idea. So yes, I appreciate you for tuning into the podcast. For those of you who hung in here the whole time, bitch, I'm the real. You've been listening to the fake your whole motherfucking life. Bitch, this the real. People been telling you they don't care. People been telling you they don't give a fuck. Bitch, I live it. I don't. I don't care. I don't give a fuck. I don't. About certain things. Certain things I care about. All my kids, I love. My husband, I love. Myself, I love. Bitch, I love me some me. All the other shit to the wayside, bitch. I don't even got my side teeth, bitch. You think I care that you don't like it? I don't. Because I know somebody that like it, ho. How about that? How about that? All right. This is the last thing I want to say. Tune into the podcast, Hood Rat to Harvard, on all platforms. You won't be disappointed. I have a growing following. I made it in the top 20. I make it in the top 20 every time I post. I do not post every week, but I do post at least once a month on my podcast on something pertinent to the community. You will like it. You will enjoy it. I encourage you to watch on YouTube. Follow me on TikTok, the X, the Malcolm X, the Facebook, and the Instagram. And you can also follow my business pages too, thelawchick.com, on all platforms as well. I'm there. Hello and goodbye.